Be ready. 5 seconds. Start. It is well settled that in exercise of revisional jurisdiction under Section 482 of the Criminal Procedure Code, the High Court does not, in the absence of perversity, upset concurrent factual findings. Stop. It is not for the revisional court to reanalyze and reinterpret the evidence on record. Stop. As held by this court in a case, it is a well established principle of law that the revisional court will not interfere even if a wrong order is passed by a court having jurisdiction in the absence of a jurisdictional error. Stop. The answer to the first question is therefore in the negative. Stop. In passing the impugned judgment and order dated 21 November 2017, the High Court misconstructed Section 139 of Negotiable Instruments Act, which mandates that unless the contrary is proved, it is to be presumed that the holder of a check received the check of the nature referred to in Section 138 for the discharge in whole or in part of any debt or other liability. Stop. Needless to mention that the presumption contemplated under Section 139 of the Negotiable Instruments Act is a rebuttable presumption. Stop. However, the onus of proving that the check was not in discharge of any debt or other liability is on the accused drawer of the check. Para. This court held that both sections 138 and 139 require that the court shall presume the liability of the drawer of the checks for the amounts for which the checks are drawn. Stop. Following the judgment of this court in State of Madras versus Vidya Devi, this court held that it was obligatory on the court to raise this presumption. Stop. Section 139 introduces an exception to the general rule as to the burden of proof and shifts the onus on the accused. Stop. The presumption under Section 139 of the Negotiable Instruments Act is a presumption of law as distinguished from presumption of facts. Stop. Presumptions are rules of evidence and do not conflict with the presumption of innocence, which requires the prosecution to prove the case against the accused beyond reasonable doubt. Stop. The obligation on the prosecution may be discharged with the help of presumptions of law and presumptions of fact unless the accused adduces evidence showing the reasonable possibility of the non-existence of the presumed fact. Para. Presumption of innocence is undoubtedly a human right as contended on behalf of the respondent accused, relying on the judgments of this court in Satish Sharma versus State of Maharashtra and another and Rajesh versus CBI through its director. Stop. However, the guilt may be established by recourse to presumptions in law and presumptions in facts as observed above. Stop. This court reiterated that in view of Section 139, it has to be presumed that a check was issued in discharge of a debt or other liability, but the presumption could be rebutted by adducing evidence. Stop. The burden of proof was, however, on the person who wanted to rebut the presumption. Stop. This court held, however, this presumption coupled with the object of Chapter 17 of the Act leads to the conclusion that by countermanding payment of a post-dated check, a party should not be allowed to get away from the penal provision of Section 138 of the Act. Stop. In Kumar Exports versus Sharma Carpets, this court reiterated that there is a presumption that every negotiable instrument duly executed is for discharge of a debt or liability, but the presumption is rebuttable by proving the contrary. Stop.